A little past midnight at the Palo Alto City Council meeting on October 3rd, the controversial issue of medical marijuana was up for discussion. A citizen initiative had gathered enough signatures to put the opening of 3 medical marijuana dispensaries in Palo Alto on the agenda. City resident Tracy Chen approached the podium.
I have chronic neurological and autoimmune problems that I suffered with for more than 20 years before trying this. But when you're in chronic pain and you can't function and you can't work and you can't socialize, and you find something that brings back your whole life, I can't believe you guys would ban it. I do everything better with the medicine.
The council meeting highlighted just how complex this topic is. By federal law, selling or possessing marijuana for any reason is a crime. California Proposition 215, though, permits marijuana for medicinal uses. In 2009, Attorney General Eric Holder announced that the federal government would not prosecute medical marijuana users in states that permit it. Because of conflicting legislation, medical marijuana patients in California have been caught up in legal battles for over a decade. However, all that is about to change. Last Friday, 4 United States attorneys in California announced a federal initiative to crack down on medical marijuana shops. In the past week, shop owners and their landlords received letters from federal prosecutors. If the shops are not closed in 45 days, the letter states, owners will face property seizure and prison. Melinda Haig, the U.S. Attorney for Northern California, explained the reasons for the initiative.
Despite the fact that these marijuana stores operate in violation of federal law and oftentimes in violation of state law, we simply don't have the resources to address them all. In the Northern District of California, I have decided to focus initially on stores that sell marijuana and allow people to smoke marijuana very close to schools, parks, and other places where children learn and play.
Dr. Keith Humphreys, current Stanford psychiatry professor, is a former drug control policy advisor to the Obama administration. He believes that due to resource constraints, the federal government will pick egregious cases that they can win to send a message to other state dispensaries.
I mean, the federal government can't enforce, marijuana law in California. They can do symbolic actions, but only 1 in 6 law enforcement agents are federal. So if states decide they don't want to do something like marijuana, the federal government is really limited in what they can do.
San Jose's All-American Cannabis Club doors are currently open, but the question is, for how much longer? The owner, Dave Hodges, said that San Jose recently passed an ordinance cutting the hundreds of city dispensaries down to 10. Additionally, all cannabis products must be grown on site. The remaining dispensaries that can handle that volume of cannabis on site may become potential targets of the new federal initiative.
Limiting to 10 collectives, there's 100, cutting it down to 10 would be 10 mega facilities. Each of those facilities would definitely have to grow more than 1,000 plants, all on site, produce everything. And yeah, the way the community looks at that, that is not a collective.
San Jose residents have collected 30,000 signatures to call for a referendum.
San Jose has really come together to pull off a referendum, but it is looking like it's going to happen.
Perhaps the only way out of this legal web is a Supreme Court case that will settle matters once and for all. Professor Humphreys comments.
It is possible that what will happen is this entire issue will be jumped by straight legalization. Then you'll have a federal-state fight, and there'll be a Supreme Court judgment about whether or not state can do that.
I'm Joyce Ho, reporting for the Peninsula Press in the Stanford Graduate Program in Journalism.